Okay, good afternoon, everybody, and welcome to the Appellate Division First Department. We have about 6 hours of argument time requested, so I have to ask that you please just request the amount of time that you really need. Remember, we've had your briefs and your records. We are familiar with the cases and just want you to hone in on the most important points. So let me call the calendar. Okay, first case, People versus Rivera. Okay, submitted. Kwan versus Geico General. You want 2 minutes? Okay, so no one for appellant, 2 for respondent. R. Annette versus DocMD. Okay, you got it, 2 minutes. Boon Job versus 37 West 20th. That is going to be marked submitted in anticipation of a potential settlement. People versus Erica Murphy.
Good afternoon, Your Honor. 5 and 2, please, for appellant.
Okay.
Respondent 3, please.
Okay, you got it. 5, 2, and 3. There were 2 appeals on Murray versus City of New York. And nobody. Okay, so those are submitted. People versus James Smith. Okay, 6 and 2, and respondent. You got it. 6 and 2 and 5. Medallion Financial versus Rucker.
Yes, Your Honor. Respondent ready for the counsel for respondent ready for the respondent.
No appellant here. Do you want to submit or do you want?
You can take it on submission.
We'll take it on submission. Okay, thank you. Fernandez versus Hoke.
Appellant 8 and 2, please.
And there were 2 respondents here.
Respondent Health Hospital, respondents 5 minutes.
Respondent Sickness Hospital 5 minutes.
Okay, so I'll give you 7 and 2, 5 and 5. Thank you. People versus Robert M. Submitted. 75 First Avenue versus United Glass.
Appellate, good afternoon, Your Honor. 11 minutes and 2 for rebuttal, if I may.
Okay, I'm going to give you 5 and 2 and 5. If there are more questions and more issues, we'll follow up with it. Thank you. Woods versus Harris Camden. Okay, so plaintiff appellant.
Appellant present 5 and 1.
5 and 1. Okay, so 5 and 1. Okay, so I guess should we start with the delivery defendants? Are they here?
Respondent Harris Camden 2 minutes, Your Honor.
Okay. What about the rest of you respondents?
Your Honor, respondent, Infinity Safety Quality, 2 minutes.
Okay, and
Yeah, I will take 2 minutes here.
okay, and anybody else? Okay, you got it. So it's 5 and 1 and 2, 2, 2, and 2. People versus Bryant.
Respondent 2 minutes, Your Honor.
4 and 1 and 2. Verna versus Little Richie. Do you want to, since the appellant isn't here, do you want to submit or do you want to 2 minutes? Submission. Okay, mark that submitted. Thank you. Iberdrola Energy versus Oak Tree Capital.
Appellant 8 minutes and 2 minutes.
And respondent? And how much time would you like? Okay, 8 and 2 and 6. And Hotel 237 is submitted. And then on the Article 78 calendar, we have Trump versus Angoran, and that is submitted. Okay, so thank you very much. First case for argument is Kwan versus Geico General.
Good afternoon, Your Honor. Cheryl Corman for the respondents. I'll be brief.
The Supreme Court properly denied the petition to vacate the master arbitration award, which was neither irrational nor arbitrary, capricious, or against settled law. I would direct this court's attention to the case of Matter of New Millennium versus Progressive, which was
That's the one you just handed up.
Yes, it was decided by this court on October 24th. It's directly on point and controlling. So unless the court has any questions, I'll just quickly move on to the second issue, which is neither preserved or appropriate for this court to be reviewing. It wasn't raised at the arbitration or the master arbitration level, so it was appropriately not determined in conjunction with the Article 75 proceeding, and we don't see any reason why the court should reach the merits of that case either here. So really, unless the court has any questions, I'll simply rest on my brief.
Any questions? Okay,
Thank you very much.
thank you very much, and have a nice afternoon. Next case for argument, R. Annette. We also just have the respondent for 2 minutes, right?
Good afternoon. May it please the court, Ivan Torres with Cale Gordon Reindell, pro bono counsel to the respondent and the mother, Annette R. I'll be brief as we think the extensive record here easily provides a sound and substantial basis for the court's ruling both on the issue of custody and visitation. In July 2020, this court affirmed the family court's initial modification of the visitation schedule on the basis that, quote, the record clearly establishes that the father continued to have difficulty with the child's asthma medication. Under the modified visitation...
Counsel, this appeal is very narrow, correct? The father's only challenging the medical decision-making being reposed in the mother, correct?
With respect to custody, yes, and the father is also challenging the visitation schedule. On the visitation schedule, under the modified visitation schedule, which was before this court in July 2020, the father was granted twice weekly overnight visits rather than continuing extended multi-night visits, which existed prior, to ensure that the child's asthma was not left ignored or left untreated by the father as it had been in the past. This schedule has remained in place since, and under it, the child's best interest has been and continues to be well served. Indeed, as the child himself stated through counsel below, quote, he really likes the way things are going right now. In fact, even the father acknowledged the stability that the child benefited from under the current visitation arrangement. The father now not only looks to upend the visitation schedule, but, as Your Honor recognized, also senselessly asks for joint medical decision-making despite his history of medical neglect. The petitioner never raised this point below, and respectively, we believe that the father waived that argument. But even on its merits, the court below is well within its authority in granting sole legal custody to the mother. Not only was there a long record of medical neglect by the father, but there's also a long record of abuse and acrimony from the father towards our client. And with that, we believe this court should affirm.
Thank you. Thank you, counsel. People versus Erica Murphy.
Good afternoon. Good afternoon. May it please the court. Ben Schatz, Center for Appellate Litigation for Ms. Murphy. Ms. Murphy's sentence is excessive, and we're asking the court to reduce it. What is not in dispute here is that Ms. Murphy acted violently. It's not in dispute that this is a really tragic crime. It's not in dispute that she committed a crime. She committed a B felony. It's not in dispute that she deserves punishment. This is a question of proportionality. It's a question of what is fair. And it's really important that this court, because no court has yet, take a look at the sentence that Ms. Murphy received and compare it to the sentence that her co-defendant received.
He got the same sentence of 12 years, is that correct?
That's right. And 12 years was a sentence that the people believed served the ends of justice. They thought that was an appropriate fair amount of time. The conduct that my client engaged in, absolutely reprehensible, no question. Nowhere close to the barbaric conduct that her co-defendant engaged in. we're asking the court to reduce the sentence to the minimum of 5 years or something closer there too. I'll address the appeal waiver unless there are any questions on the merits. There is nothing in the plea transcript or otherwise in the record that makes clear that Ms. Murphy understood what an appeal waiver was. There is no question and answer colloquy where that question is asked and she answers it affirmatively. Additionally, there are a number of problems with the appeal waiver. The important advisal that courts must make that the right to an appeal is a separate and distinct right from the trial rights that are waived automatically upon the forfeiture upon a plea. That was not made clear to her. The court does use the language separate and distinct, but not in a way that makes any sense with respect to what rights she's giving up and what rights she knows that she has. The court also describes the rights that Ms. Murphy is purportedly giving up on appeal as legal rights, which wouldn't even cover the excessive sentence claim that we're raising now in the first place.
What about the written waiver?
The written waiver is there. The Court of Appeals has said the written waiver in and of itself is insufficient to satisfy the requirements of a knowing, intelligent, voluntary waiver. And I think it's especially important to keep in mind in this case that Ms. Murphy is at the time, 20-something-year-old high school dropout. She's essentially a young mother of two who had a YO but otherwise no involvement in the criminal justice system. I think something as complicated and technical as a waiver has to be done to perfection, and it wasn't here. Thank you.
Thank you.
May it please the court, Aiden Sanchez for the people, appearing pursuant to the practice order under the supervision of ADA Hamilton. Your Honors, in this case, the defendant's claim is foreclosed by the defendant's valid waiver of appeal.
Counsel, I don't think that's a very strong argument. Based on what your opponent just said, it wasn't made clear that these were separate and distinct rights. The court says as a separate and distinct condition of your plea. So there's no dissection of the rights as opposed to trial rights.
The court did delineate between the rights that are automatically forfeited and the rights that the defendant is waiving with her waiver of appeal, and the colloquy was supplemented by a written waiver, which makes that clear.
Yeah, he kind of leans into the written waiver, doesn't he? In other words, he doesn't recite what's in the written waiver. He just says, did you review this with your attorney?
Correct, Your Honor.
Is that enough?
Looking at the totality of the circumstances here, Your Honor, where the court did engage in a colloquy with the defendant, with defendant's counsel present, and the court did ask defendant whether he reviewed the waiver and understood what he was waiving with counsel present, and the defendant did agree to the court that he understood and signed the written waiver.
So even if there was a bad waiver here, if we get to the merits, Mr. Aponte is actually the one that came in and threw the victim, which caused his serious injuries. That's not what the defendant here did, Ms. Murphy. So why should she have been sentenced to the same 12 years as Mr. Aponte?
You are correct, Your Honor, that the defendant in this case did not take that physical action that caused directly those injuries. However, the defendant was acting in concert from the outset of this incident. She first is the only defendant with a colorable motive in this case because the defendant and the victim are former boyfriend and girlfriend.
And he took her iPad? Is that what I understand?
Correct, Your Honor. The defendant in this case was upset about the iPad being stolen and confronted the victim on the street and called over Mr. Aponte, the co-defendant. And from the outset, they began engaging in a physical altercation with the victim where the defendant started to punch and beat the victim with a broom-like stick and then called over Mr. Aponte to engage in that physical dispute. They both engaged in punching the victim until Mr. Aponte took the victim and slammed him onto the concrete. And For those reasons, the people are asking that this court affirm the judgment of the lower court.
Okay, thank you.
Thank you.
Unless the court has any questions, I'll rest on my briefs. Thank you.
Okay, thank you, and thank you very much for appearing today under the special order, and appreciate that very much. Thank you both. Okay, the next case for argument is People versus James Smith.
Good afternoon, Your Honors. May it please the Court, Elizabeth Lagerfeld from Center for Appellate Litigation for Mr. Smith. I'll argue today that the lineup in this case was unduly suggestive and should have been suppressed. Time permitting, I'll also cover suppression of Mr. Smith's statements under interrogation. In this case, Your Honor, the lineup speaks for itself. Mr. Smith is the only person who matches the witness's description of a white male in his 40s or 50s with a small build. He's also the only one who's gaunt, sickly, and looks like he's addicted to heroin.
Right, you used the word scrawny in your brief, I believe. Scrawny.
Yes.
But the other people in the lineup maybe are not quite as emaciated looking as your client, but they're not so far off. I mean, I don't know, just looking at the lineup.
Well, if we look at their weights, so Mr. Smith was 130 pounds. The other participants were from 140 to 190. And if you look at,
They're wearing
their faces,
the hospital, sorry to interrupt, but they're wearing the hospital scrubs, correct? And so that kind of balloons out their build a little bit.
well, yes, Your Honor, but if you look carefully at the lineup, you'll see this hospital scrubs are actually resting on the stomachs of several of the fillers. You can also see the arms, you can see their faces, and you can see that Mr. Smith still sticks out like a sore thumb compared to the other fillers. You can also see that they're all darker skinned than he is, particularly the two smallest, number 3 and 5, who are the closest, the only ones remotely close to his size. Do people need a copy of the lineup? I see people shuffling.
No, I have.
Okay. So, given all of this, there was more than a substantial likelihood that Mr. Smith would have been singled out and the lineup was unduly suggestive. If there are no other questions.
Of course, there was some ID. He didn't appear for most of the court appearances, correct?
During the trial, that's correct, yeah.
And so there was a photograph of him that a number of the witnesses identified in the
That's
case.
correct, yes. And
Are you saying that that was somehow prejudiced by the lineup?
well, yes, Your Honor, and also the basis, so when there's a lineup identification, there's no requirement for, excuse me, for the prosecution to provide independent source for an in-court identification in this case. So those in-court identifications, with the exception of one, were all, in a sense, based on the lineup. Okay, and moving on to the statements under interrogation. Here, the officer's testimony about what happened in the interrogation is simply not credible. And that's not based on what Mr. Smith says, that's based on the science. We know this is based on testimony that was incorporated into the record on stipulation of both parties, that heroin withdrawal begins within 8 to 12 hours of last use. And the officers are testifying that a full day after Mr. Smith's arrest, not his last use, he was very alert, he spoke normally, he didn't appear to be intoxicated, he was calm, he was relaxed. They didn't testify, as the people suggest on appeal, that he was in mild withdrawal and got worse. They testified that they wouldn't even acknowledge that he was in withdrawal at all. They're giving evasive testimony. Officer McDougall says, you know, he was on the floor, he wasn't feeling well, but he didn't recall whether that was because of withdrawal. So this is really evasive and not credible testimony based on the science of how heroin withdrawal works. And we're looking at a 2-day detention of someone who everyone agrees was a severe heroin addict there's no video of the interrogation, and conveniently, after the interrogation was finished, he then was somehow sick enough to take to the hospital. And I think you have to be really skeptical of that.
But would the heroin withdrawal be fact-specific to the individual's use? So do we have any evidence here as to when the defendant last had ingested heroin, the amount of heroin, the potency of the heroin? Because the general statistics obviously are very helpful and useful, but I think there's probably some factual variables that are going to that might tend to support or undercut your credibility argument here.
Well, here's what I'll say. The testimony says that heroin withdrawal starts within 8 to 12 hours. We're talking about the day after his arrest. So even if he were to have shot up directly before the arrest, which would contradict the record because everyone's saying, he wasn't intoxicated, he was fine. Mr. Smith himself said it had been a while since he last used, but even if you don't want to believe that, we're still going to be well into heroin withdrawal. And what's just not credible, no matter what, is that he was perfectly fine, which is basically what they're testifying to during this
He did admit that, maybe not for the entire period, but that he was cogent and lucid. Those are two words he used, correct?
Well, yes, he did use those words, but it's taking it somewhat out of context. So what he said, he was asked if he understood the questions, and he said, for the most part, when I was cogent and lucid, but there were times that I was so sick, this is paraphrasing, that I was so sick that I couldn't understand what was going on. So he's saying some of the time he was cogent, some of the time he was not. So the key thing, I just want to wrap up here, it was the people's burden to show beyond a reasonable doubt that these statements were voluntarily made, and they didn't carry that burden. So for that reason, the statement should have been suppressed and a new trial is warranted. Thank you.
Thank you.
Good afternoon, Your Honors. Franklin Gunther on behalf of the people. I'd like to start with the lineup. I think the clearest indication that this was not a suggestive lineup is that two of the witnesses who appeared for it did not positively identify the defendant. We had a total of seven witnesses who came and viewed it, and two of them could not make a positive identification. We have submitted the lineup for Your Honor's review as a reference. I would submit that all the identifying characteristics that the witnesses identified, that he was white, that he had gray hair, that he was middle-aged, all of those were accounted for. Now, conceitedly, not every witness in the lineup is white, but we would submit that their skin tones are reasonably similar, and for that reason, the lineup is not unduly suggestive. With respect to the Miranda issue, I agree with counsel. This is essentially a credibility determination, and we would submit that not only were the officers credible in the testimony that they gave, they were candid about the fact that they did see defendant ill at one point, albeit later in the evening, but there was nothing inconsistent about their testimony in that regard. And as Your Honor noted, defendant himself admitted that he was cogent and lucid for the most part during the interrogation. And so it essentially comes down to the court made a determination that the officers gave consistent testimony and that the rest of defendant's testimony regarding the night he was arrested simply wasn't believable. And for that reason found that his statements about the fact that he was being induced into making statements was just not credible. And unless there are any questions, we rest in our briefs. Thank you.
Okay, thank you. Counsel, you have 2 minutes.
Okay, Your Honors. I'll start with the two witnesses who didn't positively identify Mr. Smith. I don't think that tells us anything whatsoever because we don't know what the starting point for those witnesses was. They both gave kind of unequivocal statements. It looks like him, something like that. For all we know, they wouldn't have made any identification at all if this lineup hadn't been suggestive. So I don't think, without knowing where they started, I don't think that's probative whatsoever. Moving on to the matching of the witness descriptions. I think the people are admitting not every witness actually matches this description because not all of them are white, but also the description that the witness gave, and I would also note some of them are not small build, okay? But the witness that the description that the witnesses gave is not the only thing you can consider. I think Mr. Smith just sticks out like a sore thumb here. So I just ask you to look at the lineup. And as far as the statements go, I would just
how would that bear on the fact that a couple of the witnesses didn't identify him at all? Just made no identification of anybody at the lineup.
I'm sorry, Your Honor, could you repeat the question? I didn't quite hear that.
How would that bear on the fact that there were a couple of the witnesses that weren't even able to identify him? So if he stuck out that much, wouldn't they have been able to choose him? I mean, doesn't that go against, to some extent, your argument?
Well, I wouldn't say so, Your Honor. The two witnesses you're talking about, they actually did identify him, just not unequivocally. They said, that looks like him. I think that's him, but I couldn't be sure, something like that. I don't have the exact quote, but they did make some selection that it was number 2. So I think without knowing where they started from, we don't know, again, maybe if it had been a better lineup, they wouldn't have identified him at all. So without knowing where they started from, that doesn't tell us anything about the suggestiveness of the lineup. Okay, well, I'll just rest on my briefs then. Thank you, Your Honors.
Okay, thank you very much. Next case for argument is Fernandez versus Hoke. Good afternoon.
Good afternoon, Your Honors. May it please the Court, Christopher Della Carpini for the appellant, Mr. Fernandez. So Justice Edward granted summary judgment here because really the plaintiff's expert's opinion supposedly was not sufficiently supported by the evidentiary record. That's not quite the standard she quotes from the Court of Appeals Diaz decision a few pages earlier, which says it's whether the opponent's expert's opinions are unsupported by any evidentiary foundation. And throughout her 16-page opinion, she doesn't really identify the opinions that she says the plaintiff's expert didn't support with evidentiary foundation. This is a complicated case. By my count, there's 1,696 pages of medical and pharmaceutical records, and there's 2 sets of conflicting medical expert opinions, but it's not a complex case. Mr. Fernandez's expert identified really one departure: the failure to emergently treat his stent and the urethral obstruction. And he just identifies that over and over again. Every time Mr. Fernandez goes for treatment by either the HHC defendants or the St. Luke's defendants from November 2017 all the way up to the beginning of April 2018. And he also explains how that repeated departure, that repeated failure to treat it emergently, leads to the conditions that he starts complaining of as early as January 2018, and that he's complaining of when he's finally taken to New York Presbyterian.
One thing your expert talks about is the failure to educate him to get medical clearance. You know, and he doesn't set a standard there. There's no way to determine if that is a departure or not. And he was told, was he not, to get medical clearance for the procedure to remove the stent?
He was told repeatedly that he was going to have to go get the clearance. Yes, he was sent away to go get the clearance rather than be treated emergently, which the expert also says is a departure. He also comes back saying that places won't take his insurance. In fact, he's sent by Dr. Hoke back to the Harlem Hospital Urology Clinic after Dr. Hoke has documented that clinic won't take his insurance. So he's not getting the help he needs from these doctors. He's certainly not getting treated emergently. He's never even asked to be admitted. That's what our expert says was a departure. This had to be treated emergently. That's what he means by definitive treatment.
Was there record support that the plaintiff was experiencing an emergency type condition or something that would require emergent intervention at that point?
He is complaining as early as January 10th, 2018, of the left flank pain, hematuria, back pain, lower abdominal pain. These are exactly the conditions that the expert says were the risks that required Dr. Hoke in November of 2017 to schedule the emergent removal of that stent. As the expert says, urethral stents are not meant to be permanent. You take them out as soon as you can, as soon as the problem is alleviated. Why? Because there's a risk of infection, of hematuria, of sepsis, all of which he presents with at New York Presbyterian when it's apparently too late.
When was the stent put in?
Stent was put in the procedure on November 11th to 12th, 2017 by Dr. Hoke at Harlem Hospital. And at that time, he puts in the record, we're going to remove the stent but later by elective procedure. That's the first departure we point out. Now, he's not complaining yet. The thing has just been put in. 2 months later, he's back at Harlem Hospital.
There was a procedure that was scheduled on March 28th. There seemed to have been some dispute.
Was it, though? Exactly.
Well, that's what, was there some dispute in the record as to whether or not your client knew that this was scheduled?
Yeah.
whether they called him to let him know about it. I mean, what happened there? Because there was it appears that there was, but there's questions about
Your Honor,
that.
right
You could
there,
address that.
We have a factual dispute. Whatever you think of the expert opinions, there is a factual dispute, one of a few, that precludes summary judgment. The St. Luke's defendants say, and their records indicate, we told him he's got a procedure scheduled here on March 28th. They don't explain how he's going to get that procedure without having insurance. They don't explain why they're scheduling it without having gotten clearance for him, why they're not helping him get clearance for it when they could have. And Mr. Fernandez consistently denies that they ever told him about that procedure. Justice Edwards at one point says that Mr. Fernandez is contradicting himself between his testimony and the affidavit. I don't know what contradiction she's talking about, but he's rock solid on this. They never told me I was coming in for that. If they told me, I would have come. That makes perfect
He
sense.
went
He's the
somewhere
one in-
else on that day? Did he go to a different facility on March 28th, the day that he was scheduled for this, or allegedly scheduled?
No, I believe he went to Total Medical in the middle of March. March 16th is when he first went there. He's just...
Yeah, initially, but then on the 28th, he did go in for a physical exam to Total. And
Yes,
saw
to
Dr.
yes, he
Flan.
starts going to Total in the middle of March.
Right.
And eventually they finally do something about this, although Dr. Ploner and Total Medical are defendants who are still in this case. That's going to go to trial. So yes, he does go and he gets it treated, but then he's still having the symptoms. Now, the defendants experts say, well, it's impossible for the symptoms he had at New York Presbyterian to have started when he treated with us. They would have come too suddenly. Plaintiff's expert disagrees. He said this is exactly what he was complaining of when he went to Harlem Hospital in January, when he went to St. Luke's in February and March. This is a progressing disease. It's a progressing condition. It's the same mistake over and over again. If there are no questions, I'll just conclude by saying I'm still not clear what standard Justice Edward was holding the plaintiff's expert to. I don't know what she required for sufficient support in the record, but there is clearly support in the record. Plaintiff's expert is quoting from the record. He's quoting from Dr. Davis Joseph's urology consult, where he sees the calcifications. There's evidence to support that record. There's enough here to go to a jury and decide the question of whether these were departures and contributed to the condition.
Okay, let's hear from your adversaries, and you'll have a couple minutes for rebuttal. Thank you.
Thank you, Your Honors. May it please the Court, Hannah Sorokin for the Health and Hospitals respondents. Your Honors, the experts here all do agree that Mr. Fernandez's injuries, which are undoubtedly significant and tragic, were the result of an obstruction in his kidney that caused an infection and ultimately resulted in sepsis and gangrene. That obstruction was not present on January 10th. It was not present on April 3rd when he was seen by any doctors at Health and Hospitals at the Harlem Hospital emergency department. And in fact, it was a Health and Hospital physician, Dr. Hoke, that initially treated an obstruction back in November. So at that visit, that very first visit, Mr. Fernandez did present to a Health and Hospitals facility with an emergent condition. He had an obstruction that was preventing urine from traveling from his kidneys to his bladder. That was treated by Dr. Hoke with a stent. And in fact, Mr. Fernandez's expert concedes that that was within Dr. Hoke's discretion for that
But
November.
didn't the plaintiff's expert also say that that was not to be a long-term situation, that it needed to be removed, and yet it was not removed until much, much later?
That's correct, and in fact, Dr. Hoke was clear about that with Mr. Fernandez himself, that there was going to be necessary elective follow-up treatment, that in that November visit, the emergency condition was treated. So the stent allowed urine to flow from the kidneys to the bladder. That was treated. That was the emergency on that day, and that Mr. Fernandez would need to go for follow-up care to remove the stent and the kidney stones that he had. And he was initially referred to the urology clinic at Harlem Hospital. That clinic did not take his insurance. At the subsequent visit on January 10th, where again, his condition was not emergent. There's no obstruction.
But isn't that exactly what the plaintiff's expert says, that it was at that date, and you should have done something on January 10th?
The plaintiff's expert really is focusing on the insurance. He focuses on the fact that on January 10th, Dr. Hoke referred Mr. Fernandez to the urology clinic again at Harlem Hospital, even though that we knew at that point they didn't take his insurance. But Dr. Hoke also referred him to.
So wait, but I thought that on January 10th, the plaintiff's expert said you should have helped him get his insurance, but also didn't the plaintiff's expert say on that day you should have admitted him for treatment?
So he does only say, and I'll also note that Mr. Fernandez's expert doesn't say that his medical condition was an emergency on that day. He says ultimately that he should have been treated, quote, semi-emergently.
What is that? I should have asked that. Do you understand? What does that mean, semi-emergent?
I don't. He doesn't explain what it is. It seems from everything else he's saying that it was because he argues that Dr. Hoke's referral was impossible because he referred him back to that urology clinic. But he ignores that Dr. Hoke also referred Mr. Fernandez on January 10th to see his primary care physician, which is, primary care physicians regularly provide referrals to their patients. So in addition to treating the discomfort he had, and I'll note that the Health and Hospitals expert, to a reasonable degree of medical certainty, determined that the symptoms he was having on January 10th were stent colic. That's not an emergency condition. Mr. Fernandez
It was negative for infection on January 10th, correct?
They did take some testing that day, but I believe that those tests were did not indicate infection. I'm not clear from the record when those results.
So that would indicate that he didn't need emergency treatment that day, right?
Correct. He did not need
tests, right.
emergency
Okay.
treatment.
Right. So I guess, all right.
Correct. He did not need emergency treatment. He was referred to the urology clinic and also to his primary care doctor. He was advised he needed follow-up elective care and to seek that elsewhere. And that's ultimately what he did. And what's clear here is that the obstruction that ultimately caused his resulting injuries, that led to the infection, that resulted in sepsis and gangrene, that only came about after co-defendants, who the case is still continuing against them below, co-defendant Total Medical removed the stent.
Yeah, but the problem was the plaintiff's expert is saying that the stent was neglected. It shouldn't have stayed in that long. I know they're not the ones that removed it, but he's saying that the doctor should have realized that the stent was getting encrusted, and that's what started the whole line of situations leading to progressive and worsening situations, which ultimately led to the final situation. So I don't see how it's unconnected.
Well, ultimately, what led to the final situation was the obstruction that resulted only after that stent was removed. So there's no indication in the record that the stent was causing an obstruction. There was some calcification, but when the stent was removed, it was determined that wasn't significant. And on January 10th, the stent had been in for about 2 months. Plaintiff's own expert said that no more than 3 months should a stent be in. So even by his own timeline, it was within that. Dr. Hoke in his deposition said 6 months to a year. But even at that January 10th visit, there's no medical emergency that would have warranted being admitted. Dr. Hoke is an emergency department physician. And if I may just briefly conclude, Your Honors, the April 3rd visit, he did have an infection. He was treated for that, which ultimately, the treatment he received that day allowed Total Medical to clear him. He didn't have his clearances during that visit, the cardiology clearances that he needed for surgery to remove the stent and the kidney stone, and he had an infection. And ultimately, the obstruction was a result of removing the obstruction only came about after the stent was removed without replacement and without removal of the kidney stones, and that happened after he was last seen at a Health and Hospitals facility. Thank you.
Okay, thank you.
May it please the court, my name is Dan Ratner. I represent the St. Luke's Roosevelt defendants in this case. What plaintiff's experts said was that and by the way, both sides agree, that you don't want to leave a stent in for too long. Everybody agree with that. And in fact, the record shows in the medical record that my clients were trying to schedule the removal of the stent and also the surgical removal of the stone itself. It's undisputed that the patient was seen on the 20th, the 22nd, I believe it was the 5th, the 9th, and then I think 2 more times after that. Each time trying to get this appointment scheduled, but first the plaintiff needed to have pre-surgical clearance and a CT scan, which was not done. Now, plaintiff says he was not told to do that. But the problem is during his deposition, he said he didn't remember. He didn't say he didn't he was not told that. He said, I didn't remember. Then, of course, in opposition to a summary judgment motion, he produced an affidavit and said, oh, no, I wasn't told that. I wasn't
What
educated."
happened with this procedure that was apparently scheduled for, or not, for March 28th? That was from St. Luke's, wasn't
Yeah,
it?
but by that time, the plaintiff had decided to seek care elsewhere.
So he never came in, you say it was scheduled, he said he didn't know about it, and after that, he never came back. He never came in for that day, and he never came back to you again.
That is correct. He said he put in an affidavit that he lost faith in my client somewhere along the line because he wasn't told that. But the medical records are very, very clear. They were not contradicted until the affidavit was produced in opposition to a summary judgment motion. But I also want to say this. Plaintiff's expert said, yes, a stent should be removed as quickly as possible. But then, it's funny, he skips over the fact that 2 days after the initial visit on the 20th, he was seen by a urologist. He skips over the fact that there were no symptoms at that time. And in other words, the plaintiff was stable at that time. So, okay, let's go ahead and get the surgical clearance. Let's schedule this in the ordinary course. It is not an emergency. If it was an emergency, that's a conclusory statement by the plaintiff's expert. He doesn't say anything. He doesn't rebut our expert who said there were no symptoms at that time. There's no reason to admit
So
plaintiff
let
at
me,
that time.
so your experts say that there was no need to take out the stent on January 28th because there were nothing going on that day, right?
what do you mean?
I'm sorry, yours is the next one, right?
Yeah, so we have January
March,
20th, then
right.
January 22nd,
Right,
then
right.
February. It goes into March, by which time the plaintiff was being treated by
Seen by
somebody else.
someone else. And your expert says that none of those visits was the condition of the stent such that it had to be immediately.
It wasn't an emergency. You don't do surgery without getting a
Right.
pre-surgical clearance. You
Right.
need a CT scan
Right.
in the absence of an emergency. Plaintiff's expert disagrees. He says, oh, no, it was you need to do something more. But he doesn't really spell it out.
Right,
He doesn't say
right,
why on those
Okay.
dates.
And
it needed to be done.
what did the plaintiff's expert base that on?
He's making a
I guess
general-
I'll ask that to
Well,
plaintiff.
I think I can have the answer to that question. I could try anyway. I think that he's basing on the idea that you need to remove a stent as quickly as you can because you don't want it to sit there.
But specifically on those dates?
He doesn't, if you look at page 33, if you just give me 1 second, 3396 of the record, he says, well, Mr. Fernandez returned to St. Luke's Urology Clinic on February 5th and February 19th with continued urinary retention and no procedures was scheduled. So he doesn't rebut our expert who says, wait, of course there's urinary retention, but he doesn't have any of the symptoms of infection, anything like that. He just completely ignores that. So he sort of goes straight to the general while ignoring the specific and failing to rebut what our expert had to say about the relative urgency of the situation and the need to be really careful and get a pre-surgical clearance, have a CT scan done before you go into these types of invasive procedures that we're talking
But
about.
wasn't one of the experts, plaintiff's experts, points that plaintiff had a certain set of symptoms on a given date and he should have been admitted maybe for antibiotics? Not so much that he needed surgery, but there needed to be some treatment related, responsive to those symptoms.
Antibiotics were given on the 20th, the day of the first visit with St. Luke's. Prophylactically, they were given. He was set on a course of treatment. The idea was to keep the patient, the plaintiff, stable, get him cleared, have a CT scan so you can take a look at the film and see what's going on, and then do it. And then he kept coming back, and he had not done the pre-surgical clearance. He had not done the CT scan. There were all these delays that can't be laid at the feet of St. Luke's Roosevelt. In fact, there is undisputed evidence in this record that St. Luke's actually referred him to, I think it's called the Ryan Clinic, which the plaintiff apparently was familiar with, and said, here, go get your clearance. Here's a place you can go.
Wasn't there a problem with insurance at a lot of the places he was going?
That was at the HHC, the beginning of the treatment with HHC, not my client, I don't believe. I don't remember insurance being part and parcel of this particular, as it relates to my client.
And your client was not able to provide pre-clearance for him so he could have these procedures?
Well, he was being seen by a urology clinic, and he was referred to the Ryan Clinic. Now, I don't think the law requires that we, a medical provider, and I hate to sound, I don't mean to be glib, but to take the patient by the hand one place, so that you send them for a pre-surgical clearance. And there was no evidence that he didn't understand that at the time. It wasn't until he provided an affidavit after the fact that he said he didn't understand that.
Okay, thank you.
Thank you, Your Honor.
happy to answer any questions, but before I do, I would like to just talk about this phrase emergent. Not all emergent treatment is an emergency. Emergency is what he had at Presbyterian. That's an emergency. But emergent, as you read through the plaintiff's expert's opinion, is you have to treat this now.
Well,
What is
what exactly did your experts say should have been done that wasn't done on January 10th, for example?
January 10th?
Right.
Not January 20th or 22nd or
I mean,
all those
yeah.
other dates until April when he was under the defendant's care. At the very first date,
Yeah.
he should have had should have been admitted for treatment, should have had the stent removed then. It had already been in for almost 2 months.
Without any symptoms, without pre-clearance, does
No,
he deal with the pre-clearance and without there being symptoms?
No, I believe the expert says that Harlem Hospital could have arranged for the, they could have done the clearance themselves on admission. And given the problems that this plaintiff had already had, that was a perfectly reasonable thing to do.
You're saying that that was a departure, that they didn't, that your expert says it wasn't it was a departure for them not to pre-clear them themselves?
Yes, they could have done the clearance themselves. They'd already seen.
But no, okay, they could have, but they didn't. But it's.
Yeah, he's saying it's a departure to not have done it then. Now, he's not in an emergency then, though he is.
Get pre-clearance? That it was Harlem's hospital's responsibility to get pre-clearance for him?
Yes, under the circumstances, it was their responsibility to get this thing out of him. It should not, they should not have been keeping it in there for 2 months, and as it goes on more, simply because he's not getting his clearance on himself. They've already seen he can't get his clearance. He's had this thing in for 2 months. And I should point out, even if there isn't an emergency on January 10th, this goes on and on, January 20th, 22nd, February 5th, 28th, March 5th. He's back at Harlem Hospital again April 3rd and 5th. So even if you think, well, it's no big deal what they let slide on January 10th, what about April 3rd? This treatment went on and on and on. This is a slow motion train wreck, and they're not doing what our expert says they should have done to stop it.
Okay, thank you.
Thank you very much.
Thank you all. Next case for argument is 75 First Avenue. Good afternoon.
Good afternoon, Your Honor, and may it please the court. Trevor Gomberg, Levitt LLP, for the defendant, Appellant O'Keefe's. Your Honor, there are 2 issues. Issue 1, whether plaintiffs' express and implied warranty claims should have been sustained. They should not have been sustained. First, the court below, Your Honor, erred as a matter of law and fact by disregarding the absence of privity and the rule that no warranty claim can exist in the absence of privity. Your Honor, this...
So I guess so we start with the contract itself, which expressly states no third party gets any benefits under this contract, right?
Yes, Your Honor.
That's pretty straightforward.
We agree, Your Honor.
So then, I guess there's a theory of third-party liability, third-party beneficiary.
That's exactly
So
right, Your
it's
Honor.
one of 2 ways. The contract shows it. Well, here, the contract expressly disclaims it. So the only other possibility is conduct, right?
Your Honor, I'll answer it this way, if I may. This court in U.S. Education Loan Trust versus Bank of New York Mellon says that for there to be a third-party beneficiary, that third party has to have rights, remedies, or claims under the contract. Plaintiff here does not have any of those, and so consistent with the Court of Appeals decision in Dormitory Authority, the recent decision, plaintiff does not have standing as a third-party beneficiary. In fact, the fact that plaintiff contends that as a third-party beneficiary further undermines the prospect of there being privity. Plaintiff's position is that it is not a party to the contract. In addition...
No, I think they're sort of, in a not very straightforward way, saying we're a third-party beneficiary under the contract. But the contract expressly disclaims that, right?
That's exactly right,
Okay.
Your Honor. Your Honor, plaintiff also is not the beneficiary of any warranty. Plaintiff does not claim a bargain for any warranty from my client O'Keefe's. Plaintiff was not a named beneficiary under this warranty.
Is this the implied contract claim now that you're on to?
Your Honor, I'm still on the warranty claims.
Okay.
I'd be happy to address the implied contract claim at this point if Your Honor would like me to. Okay. Plaintiff was not a named beneficiary under the warranty, and by its terms, the warranty did not flow to plaintiff. It only flowed to O'Keefe's immediate buyer, which the contract elsewhere defined under the terms to be the person who submitted the purchase order, that being UGS. Your Honor, but there's more. While there was never any finding that there was anything actually wrong or defective with the glass, O'Keefe stepped up and in its discretion, it delivered replacement glass. That is the maximum liability that the limited warranty owed to UGS provided for. Now plaintiff wants its installation costs. However, as Justice Scarpula pointed out, the damages, liability, and warranty disclaimers preclude that. Second, the court below erred as a matter of law. In fact, it disregarded that the plaintiff, who is not a contracting party, lacked standing. And I referenced Justice Kapnick's decision at the trial court level in American Home Assurance v. McDonald for that point. Third, there were bargained for allocations of risk between O'Keefe's and UGS under the contract. In fact, that was priced into the contract.
Didn't at some point the plaintiff claim that there was a discussion, oral discussion, with someone, I don't know if it's president of your company, where they said, look, maybe we can talk about doing something here to help you out with the costs. I know they replaced the glass, but there was a replacement cost for taking out 168 panels and replacing the 168 panels. And based on that discussion, that he claimed that there was some additional relationship or privity?
No, Your Honor, and here's why. Because the contract precluded, the contract contains a no oral modification and an entire agreement provision, Your Honor, with respect to the subject matter. So now we're shifting to the implied contract claim. Justice Scarpella, I apologize, it took me a while to get here. Your Honor, there was no consideration, there was no legally valid consideration for this purported implied contract, and there is an express contract. Why? Because plaintiff claims it's a third-party
The
beneficiary.
express contract provides for a choice of law provision, right?
It does, Your Honor.
There's very little citation to California law in either of your briefs. Should we be concerned about that?
I don't believe so, Your Honor. We have tried to cite the California equivalent, although we weren't sure, frankly, which law this court would be focused on. We have cited both New York and California law consistent with the choice of law. For purposes of this appeal and the issues on this appeal, Your Honor, New York and California law, based on the cases we have cited, hold the same, Your Honor. If I may conclude. Thank you, Your Honor. Your Honor, plaintiff has, with respect to the implied contract claim, the four undisputed claim elements under Court of Appeals law have not been alleged by plaintiff. All they say is that some implied contract arose by its actions. The plaintiff cannot plead the elements of such a claim. There was no consideration, as I mentioned. There were unenforceable conversations. There's no indicia of terms, not even a price term, and there's no legal capacity. Finally, the notion of a third-party beneficiary to this express contract, who also had some contemporaneously existing oral contract based on the no oral modification and entire agreement provision, should be rejected. And finally, the complaint is proof positive that these are the same subject matter. Why? Because all of the causes of action asserted against O'Keefe seek the exact same damages down to the dollar. And for those reasons, Your Honor, the decision of the court below should be reversed insofar as appealed from. I thank the court for its time.
Thank you. You'll have a few minutes in rebuttal also. Thank you.
Good afternoon, Your Honors. May it please the court. Vincent Pizzuto for the respondent, 75 First. I want to tackle the privity argument, the no third-party beneficiary argument right off the bat. The contract does say that no third party can recover. However, first of all, this is a 3211 motion. The two...
You put the contract in, and the
Yeah, but-
contract says you can't recover.
The limited warranty and the specific terms and conditions are exemplars. This is not the summary judgment stage. So there's been no discovery on those.
Let me ask you this. Is there any dispute that that's what this, I mean, it's in the record. The terms of sale is in the record on appeal. That's what it says, right? Did
Honestly,
you
Your
say it's fake, it's wrong, we don't know it?
I don't know, Your Honor, because we're at the 3211 stage and we're entitled to discovery on this issue. But even separate and apart from that, the dormitory...
Did you argue that below, that there's a question as to the authenticity of the documents?
No, we just
Okay,
said there was not
so
enough
then-
of the 3211 stage.
Right, okay.
And the lower court agreed.
Okay.
But as to more substantively on the third-party beneficiary argument, the dormitory authority case is clear. If there could be third-party beneficiary status, regardless of what the contract might say, if only one party can be remedied by what was to be done. These are our windows that they admitted
So
are fully defective.
if the SAFTI didn't provide the windows, could USG have sued them for breach of contract?
Yes.
So yes, you're not the only party who can seek performance under the contract, right?
Correct, but
So that's not something
But that doesn't
that would
dis-
help
Wait,
you
wait,
in
let her
your
finish.
case, right?
that doesn't disqualify us as a third-party beneficiary when it
Well, I
comes to
think
the
the
bottom of
language
it.
of the contract that says that under no circumstance shall SAFTI be liable to buyer or any third party under tort, contract, or any theory for any other economic loss. I think that's what that basically
I
expressly disclaims.
Respectfully, Your Honor, I don't think so under the dormant authority case, because these are our windows. So at the end of the day, yes, we are the only party that could recover because we paid for those windows. They admitted, I don't understand counsel's argument that there's no admission of a defect. They admitted through the affidavit of my client, they changed their manufacturing process. They're 99% less distortion now. They came and they said those windows look like a funhouse. That's why they replaced them.
So you are seeking consequential damages
Correct.
under a contract as a third-party beneficiary under a contract that expressly disclaims your ability to get consequential damages.
But at the 3211 stage, Your Honor, I don't believe that
I
the
don't know
language of the
why you
contract.
think that unless you dispute the authenticity of the document, which you didn't do below, you're saying you do, a 3211A1 says, I've got documentary evidence that specifically disproves your case.
But the very warranty that they want to rely on, that limits consequential damages, there's other cases which the court below correctly applied that say if the warranty fails of its essential purpose, operates to deprive either party of substantial value, this frees the buyer to pursue remedies as if that clause did not exist. And the court
But you have to be a beneficiary of those warranties. So you need to be a third-party beneficiary. And hasn't the Court of Appeals made plain in the construction context that the contract, not parole evidence, but the contract must manifest that the parties intended there be a third-party beneficiary?
And correct, Your Honor. And I think the Dasney case sets forth that. And they replaced our windows.
Okay, so what in the contract, though, clearly expresses the party's intent that your client be a third-party beneficiary?
I think the fact that the contract calls for replacement of the windows if they're ultimately all determined to be defect-free, which Safety First did, and that my client is the only one that can benefit from that because we paid for those windows. And now we need to pay for the installation costs. I think they're a third-party beneficiary of a warranty that's unconscionable, or at least there's an issue of fact as to whether it's unconscionable, which the court below clearly found. And again, at the 3211 stage, I think that the denial of the motion was proper. As to the implied in fact contract, it's the Mass versus Cornell case. The consideration here was these windows didn't come out of the box looking like a funhouse. Everybody admits they distorted over time. So over time, there were 2 visits to the site by Safety First representatives, met with my client. What are we going to do about this? They replaced 33. Then they replaced some more. Then they realized that 168 panels, they're all distorting. They replaced them all. The consideration of the implied in fact contract was we didn't immediately bring suit. We allowed them to try to remedy. That's the consideration. The mutual assent is in the affidavit. Ron from Safety First met with my client.
Where is that in the record? Do you have a document that says we are not going to sue you?
Well.
I mean, that's not what you pled in your complaint, so I'm asking you where is that in the record?
I think it's at the affidavit of my client, R270 to 272. It's not in there.
Your client
expressly.
didn't say that. I've read
but
that
he
affidavit.
speaks of
So
these-
again, where is that in the record?
I think he speaks of these meetings over the course of a long period of time.
I'm sorry to interrupt you, but I want you to focus you on your statement right now that you just said the consideration was, we told you we weren't going to sue you.
I didn't say that, Your Honor, and I didn't mean to.
That's just what you said, right?
Well, it's not in
Maybe.
the affidavit, but what I'm saying is this course
Well,
of
then what
conduct-
are you saying is the consideration, if that's not it?
the giving safety first the opportunity to remedy over a long period of time, where they said, we know you guys want to talk about installation costs. Let's do that offline. Let's do that in a future conversation. That's the mutual assent. That's the consideration. It's a legal subject matter. And most importantly, they continue to argue that this implied in fact contract can't exist because there's an existing contract. That existing contract was for the supply of defect-free windows. The implied in fact contract, our argument is to pay back these installation costs to the tune of $3.9 million for a product that is admittedly defective. They admitted their manufacturing processes.
No,
have
we
changed.
know that they replaced those, but we're talking about these other costs. Okay, I think we got your points. Thank you. Counsel, you have 2 minutes.
Thank you, Your Honor. If I may briefly address some of the points counsel has raised. Your Honor, first of all, this is not an exemplar contract. The quotation between O'Keefe's and United Glass Services specifically incorporates by reference the agreement to the safety first standard terms and conditions, the standard terms and conditions that incorporates the limited warranty. If there was a third-party beneficiary, Your Honor, plaintiff would fare no better because they take the contract as they find it. Third, the purported consideration to Justice Scarpullo's point was found in a memorandum of law, record page 298. This is attorney testimony. It's nowhere contained in a fact affidavit. It is contrived. Your Honor, this plaintiff, as many times as he apparently seeks to say otherwise, was not the buyer here. And finally, the purported 2 visits to the site is nowhere contained in the record as far as we are aware and should be disregarded. I thank the court for its time.
Thank you. Thank you both. Next case for argument is Woods versus Harris Camden and everybody else. Good afternoon.
May it please the court, my name is Kenneth Fromson. I'm here on behalf of the plaintiff appellant, my client, Greg Woods. We seek 2 reversals from the trial court below. This trial court should reverse the trial court's denial of summary judgment as against the tractor-trailer defendants involved in this crash, those being defendant Luca, Camden Harris, and Banker Steele. Additionally, we ask this court to reverse the trial court's granting of summary judgment to the construction defendants who were directing and controlling work at the construction site. Summary judgment should have been granted against the tractor-trailer defendants because the driver, defendant Luca, was negligent as a matter of law, and his actions were a proximate
Well,
cause.
didn't he say that there, it was a weird series of facts here, but didn't he say that the dumpster may have run into his truck or run under his truck, which created the problem because the dumpster hit the porta potty, which hit the security booth that made the guy, your client, be injured? So he said that there may have been something that caused it, and he offered a non-negligent explanation for why this accident may have happened.
Thank you for your question, and I think it's a very important one, and the way you phrased it is also very dispositive of issues here. He never saw what happened. No one saw what happened. He is speculating. Once plaintiff appellant was able to shift the burden of proof to Mr. Luca by showing his actions of negligence and, for example, his violation of the vehicle and traffic law by not going out and assuring himself of the safety of the areas around his truck, the burden shifted. And all Mr. Luca can do on that particular fact is speculate as to whether he struck the refuse container and then the porta-john and then the security booth, or whether his truck struck it in a different order. In other words, nobody knows. I don't know. He doesn't know.
So then how are you seeking summary judgment if it could have happened that the wind blew the thing under the truck? He says he didn't see it. So how could we grant summary judgment to your client?
You can, because we offer the fact that he had an obligation under the vehicle and traffic law and under common law to do a walk around the vehicle, check for the safe circumstances. It was there to be seen. And there's no evidence in the record that this steel construction container was a runaway container. There's no credible evidence. It is pure speculation. That is what he's raising on the issue of this container that was only seen after.
So nobody observed this situation happen, this accident happen?
That's correct. And so there is the plaintiff's prima facie case of negligence against Luca, shifting the burden to Luca. And on the issue of the refuse container, it's pure speculation that should not allow summary judgment to have been denied.
So what is it that you're saying that you've proved against him, that he didn't see the thing under his wheels before he got into the truck?
No, I'm not admitting, Your Honor, that there was anything under his wheels when he left.
So what is it that you're saying that he admitted that automatically entitles you to summary judgment?
A, he did not, under 1162 of the Vehicle and Traffic Law, move his vehicle without first assuring that it could be made with reasonable safety. That's straight out of the Vehicle and Traffic Law. He never...
Did you raise that below that argument on 1162?
No, Your Honor, but I would ask, under common law, it's the same theory. He should have taken steps to assure himself that he could exit the lane.
He did testify that he looked in his mirrors and did a few other things, right?
He did, under a hurried circumstance.
He said he was rushed.
He said he was rushed, and he also said under normal business circumstances, he would have done a full walk around and inspected the area around him. Now,
Well, perhaps that level of care would exceed what's required under common law duty of reasonable care.
yes, Your Honor, that is correct. We believe what he should have done was to do a full inspection around his vehicle to see if there may have been something underneath. We're not acknowledging there was. What we do know is that he has an obligation, like any driver, to operate his vehicle when moving it in a fair and reasonable manner, and he struck several objects with his tractor trailer.
No, but that's what I'm saying. How do you get from A to B? That's
Because-
the fact that the accident occurred, right, doesn't mean that it was negligent. And if you're saying that you didn't argue the VTL point below, you're saying that he violated a common law duty to...
Yes, his common law duty to operate his vehicle in a reasonable and safe fashion when moving forward.
And what was it that, what fact are you alleging shows that he didn't?
He struck at potentially three things.
Again, that's what happened, but that in and of itself, that the accident happened, can't be the evidence that he was negligent. It had to be something else, right?
Yes, there could be, Your Honor, and if this court decides that he has raised non-negligent actions, in other words, he points the finger at the other defendants for their negligence in having a security booth dangerously in the street, and he provided an expert disclosure from Engineer Tutman explaining that the site safety plans were poorly designed, that the booth was not supposed to be in the street, and that the other construction defendants contributed, then he's not the sole proximate cause, and the other defendants belong in the case, which is why the trial court's order was inconsistent in denying our summary judgment and yet granting the summary judgment to all of the construction defendants who Mr. Luca is going to point the finger at trial with the very same claims that we have brought against those construction defendants, but those have been dismissed. So I will essentially be at trial against Mr. Luca and his expert engineer, who will blame the very construction defendants that I blamed, but the lower court said, no, they're out. So if he's allowed to blame them, why can't I? I'm out of time, Judge.
Okay, let's hear from everybody else. I'll give you an extra minute to
Thank you.
respond to them when they're finished.
Good afternoon, Your Honors. Joseph Matarazzo, representing Harris Camden, Banker Steel, and James Lucha. For the respondents, the owners and operators of the tractor trailer, we contend the trial court acted within its discretion in holding that the vehicle operator has demonstrated a non-negligent explanation for the occurrence of February 27, 2016, and that judgment as a matter of law is precluded.
Isn't it your client who set off this domino effect, that all of this happened as a result of his actions?
In addition to superseding events, the record demonstrates that the tractor trailer was moving very slowly at 5 miles per hour or less, and came into contact with a rolling dumpster that had somehow lodged under one of the rear axles of the trailer. What we don't know, and addressing Mr. Fromson's point, is we don't know how long that dumpster was there. It could have rolled into position after the truck started moving. You know, I reject this contention that it was already in place and Mr. Lucia would have observed it had he done another walk around. The record demonstrates the plaintiff himself was in that space. There was a 4-foot gap between the truck and the guard booth. He didn't see anything when he ducked into the guard booth. There were flag wavers there. They waved the truck forward. They also didn't see a dumpster there. The site safety manager didn't see anything there. There's no evidence in the record that even had Mr. Lucia walked around one last time, he would have seen this. It's within the purview of the jury to decide how long this dumpster would have been there. It could have been there after he glanced in his side mirrors. It could have rolled into position off the sidewalk after the truck started moving. The point is that the trial court got it exactly right. No one can hold as a matter of law how long this dumpster was there, and that Lucia would have seen it or could have seen it and was negligent. A reasonable trier of fact may conclude that James Lucia fulfilled his common law duty to see that which he should have seen through the proper use of his senses. This standard does not require a vehicle operator to observe everything possible, only that he make reasonable use of his senses, which he did. And just a few points in the admissible record. Prior to moving the tractor trailer, Lucia walked around to both sides of the tractor trailer for the purpose of detaching the cargo chains. He didn't see the dumpster then. Lucia did observe there were some dumpsters on wheels in the vicinity of the security booth and the portable lavatory, but none within the 4-foot gap between the truck and the guard booth. Prior to moving the truck, Lucia looked in the side view mirrors and he observed there were no obstructions in the path of the truck. Lucia was directed to leave the construction by 2 flagmen who also did not observe any obstructions in the path of the truck. The plaintiff, as I mentioned a moment ago, he was in the guard booth. He went in there through this very space, the gap between the sidewalk and the truck. He didn't see anything at that time. Honorable Adrian Armstrong correctly held that the granting to the plaintiff of judgment as a matter of law is precluded by the non-negligent explanation provided by these respondents, and we ask the court to affirm Justice Armstrong's October 20th, 2022 decision. If there are no questions, I'll rest on my brief. Thank you.
Thank you. Okay, who's next?
Good afternoon. May it please the court. I'm Gary Strong from Gaffello Laurie on behalf of defendant Infinity Safety Quality Construction. Your Honor, Justice Armstrong correctly reached a decision as to granting summary judgment in favor of Infinity Safety by looking at the elements of negligence, to be quite honest, is duty, breach, causation, damage. Infinity met the duty. They were a site safety consultant. We have an expert report from Marty Barry that explains exactly what Infinity's duties were and how they met those duties. There was no breach of a duty. The causation element of negligence against my client didn't cause the damage. There were intervening causes like the driver of the truck and anything else that may have happened. Now, the plaintiff raised an issue, well, you know, if Infinity and the others aren't there, and I'm going to be looking at Luke at trial, and Luke is going to be looking at everybody else, the expert report that was provided pertaining to the standard of care did not in any way say that Infinity breaches standard of care as a site safety contractor. These type of construction projects, there's a lot going on. There are trucks, there are people, and Infinity met every applicable standard of care in how that site safety...
It sounded like that area was particularly cramped and crowded. The huge trucks were coming in. There was traffic not too far. I mean, we looked at the pictures. The plaintiff testified he could barely get into his security booth. There was the porta potty next to it. I mean, wasn't there at least an issue of fact as to how that was all set up that could potentially lead to a problem with the trucks coming in and out like they did?
Well, again, the construction site had been there for quite some time. Trucks were coming in and out, which is true. And even if it's a cramped site, that doesn't necessarily mean that my client, as a site safety manager, had the responsibility. If the egress, and based upon the CNY and based upon who was the construction administrator and ran the job, this was done, and this is the only. There were no other accidents.
Well, that's not an excuse, but I mean, isn't that at least an issue of fact as to how this was all set up to make it more?
No, I don't believe it is an issue of fact, because based upon Martin Barry's affidavit, which was unopposed by anybody, Martin Barry identified that the proper Chapter 33 of the Building Safety Code, those elements were met. So if there's a problem with anything, one would need to look at, hey, why does the Chapter 33 of the Building Code, if that's met and you're still saying there's problems, that's a different story. My client met the requirements of the Building Safety Code for construction projects within the city of New York.
Okay,
Thank you.
thank you.
Good afternoon, Your Honors. I'm Judy Shamitzi from Wilson Alster. I represent CNY, who is the general contractor on site. Council has conceded this much on reply, but I wanted to make sure that we're on the same page with respect to this not being a labor law case, which I think is important for the general contractor. So we're talking about general negligence principles here. And we relied, of course, on Infinity's expert with respect to the safety of the site. And the reason for that is because we hired a fully qualified, competent, entirely appropriate contractor to take care of that portion of the work as we did for the deliveries and the steel and all of that. And I do think it is important that their expert opines within his specialty that this site plan was entirely appropriate. Indeed, it was approved by the city. The plaintiff is trying a similar tact with relying on Tutman's affidavit.
Was the approval of the city sort of stuck in time, though? I mean, there was an approval by this BEST team from DOB, right?
So there's a plan and there's an amendment to the plan.
And they have to approve the amendments as well.
And according to the expert, according to Barry, both the amendment and the original plan were both entirely appropriate and proper and approved. And I think in that regard, it is interesting to look at Tutman's affidavit because he says, and this is 912 of the record, he says that it was a poor site safety plan. And I thought that choice of words was interesting because it is a long way off from saying that it was in violation of any code. He's saying exactly to Your Honor's point that it was narrow, not to say that it was improper, but that it would have been nice if it were wider. Well, it's Manhattan, and things like this happen, and yes, sometimes you do. You may not have the luxury of having enough space for an inexperienced driver, for all kinds of things. I don't know what this business is with the runaway dumpster with movie-like timing that moves immediately after you've looked in the mirror, and then but even if it does that, the fact is that there is no proof that there was any deviation from the safety plan, and even if there were, the general contractor, who is not managing the day-to-day of its subcontractors, hired entirely appropriate subcontractors to perform the actual work. So unless Your Honors have any other questions, I will rest on my brief.
Thank you, counsel.
Good afternoon, Arthur J. Smith for Baxter and Smith on behalf of the James Stearns defendants.
Was your company responsible for the flaggers that were directing the traffic? Was that one of your responsibilities?
The flaggers were employees of our company, yes.
Were employees of your company?
Yes.
So weren't they deciding if it was safe for him to move?
No.
They weren't, or what else would they be doing?
Every person, the only person who says that is the plaintiff's attorney. Every person in this case said that our clients were responsible for keeping pedestrians and motor vehicles out of that area. When a truck is going to leave or it's going to come in, our job was to go out there and to make sure vehicles don't come in and don't come out. They had no duty to inspect the entire property. They had no duty to set up the parking area. They didn't put the cones in place. They didn't put the security guard where he was supposed to be. They were supposed to go out there and make sure pedestrians and trucks didn't come on the street when a truck was going in and when a truck was going out. So to the extent that the argument is that they launched the force of harm, there's no evidence that any vehicles or pedestrians were not being properly kept away from this truck that had anything to do with this accident whatsoever. The court below properly found we had nothing to do with this dumpster. The court below, literally in a quote, says there's no evidence whatsoever that they touched, moved, or even used the dumpster. Our guy's job was to go out on the street and make sure people don't come in here. That was their job with respect to this entire project. They didn't tell, the truck driver himself admits that he didn't need us to get in and out of the spot. This wasn't a crane case where you folks have all seen them, right? Where the guy's saying you got to lift the crane up, you got to lift the crane down. This guy's not telling the truck to come out or to come in. The two guys are out there to say no traffic in this area. That was all they did in this particular case. That doesn't launch a force of harm. There's no evidence that they didn't do their job properly, even if they had master's degrees in flagmanship. There's no evidence to suggest that they didn't do their job properly or that they were negligent in any way. The only person imposing duties and liabilities on my client, a plaintiff's attorney, not even plaintiff, not even CNY, the GC, not even the people that hired us. And for all of those reasons, the court was right with respect to our client below. None of the defendants, I think, just for the record, none of the defendants have put in any papers with respect to us, and the cross claims in this case, I submit, have to be dismissed, and it's extremely telling that the other contractors who supposedly are going to be blaming each other have nothing to say about our client in this case. And with that, I thank the court.
Okay, so
I'd like to bring to the court's attention that at the record on page 1117, there is the amended site safety plan in which the security booth is on the sidewalk. So to stand here and say that they were in compliance with the safety site plan would not be accurate. The one document shows it's on the sidewalk.
Did you put in any testimony or evidence to say that they were not in compliance? Do you have an expert?
I don't believe it's beyond the ken of a jury to look at the site safety plan and see that things are on the sidewalk protecting pedestrians.
I am saying that the party put in an expert affidavit saying that this safety plan covered everything, was in compliance with all codes, no problem with it.
I'm not alleging a code violation, so no.
What
Answer
are
to your
you
question, no.
alleging? Right, so what are you alleging with respect to that?
I'm alleging that it was unsafe under common law, that it would have been reasonable to place the security booth in which a pedestrian is inside on the sidewalk where the site safety plan.
Are you saying it's in the norm, it's in the ken of everyday New Yorkers to know whether that should be, the booth should be here, there, or anywhere?
No, but it is in the purview of the site safety plan members who are supposed to be adhering to it.
And we have an expert affidavit saying that that was good. So again, I'm not really sure what you're arguing. If you didn't disprove that, right, with an expert report.
The record reflects from Engineer Tutman, if the court wants to hear the opinion of an expert, Engineer Tutman's opinions are in the record, and he says that the booth was not in the appropriate place. It was not consistent with the site safety plan. So there is an engineer in the case that says that. Our position is it's not beyond the ken of a jury in such a tight cattle chute of an area.
So what was the basis of your client's statement that the flag people were directing the driver about which way, how to get out, rather than telling the driver that there was no traffic on the street?
Judge, our position, notwithstanding what you're describing as my client's testimony, our position is that Mr. Luca, the truck driver, made a claim in his testimony that he was rushed or otherwise harassed by the flaggers, and that's why it contributed.
Oh, so you're not claiming that the flaggers didn't do their job properly?
We believe you make a point of saying our client was under the impression that the flaggers helping for the safe ingress and egress of people like Mr. Luca. That is true. That's an issue of fact in dispute. As you hear, J.F. Stearns denies
No,
that.
but I mean, I could believe the sky's orange, but if, it has to have some factual basis.
And we could-
That's why I'm trying to find out, what's the factual basis of your client's belief that these flaggers were there to direct that truck rather than to make sure that there was no traffic
That's simply
on the
his
street?
observations, and I can't quote chapter and verse from his deposition, but in question of whether the sky is orange, that goes back to Mr. Luca's defense as to the refuse container. It's all speculation where that refuse container came from. He still operated the tractor trailer, but it is important to know that the site safety plans were not followed. The booth is on the sidewalk in every site safety plan.
Okay, thank you. No. Thank you anyway. Okay. Thank you all very much. The next case for argument is People versus Bryant.
Good afternoon, Your Honors. Clara Hammond-Oakley on behalf of Appellant Amir Bryant.
Okay.
Your Honors, I'm asking you to reduce Mr. Bryant's sentence in the interest of justice. At the time that Mr. Bryant was arrested here, he had absolutely no criminal record. He didn't have any prior convictions. He didn't have any prior arrests. Additionally, when he pled guilty and took responsibility for this crime, he expressed deep remorse to probation, with probation telling the court that Mr. Bryant had accepted full responsibility for his actions and stated he
Counsel,
was
did
extremely-
Mr. Bryant waive his right to appeal?
Your Honor, Mr. Bryant did not validly waive his right to appeal.
That was, okay. Because it looked pretty substantial and good to me, so tell me why you don't think it was.
So the issue with the biggest issue with the waiver of the right to appeal is that the court orally explained to Mr. Bryant that he was waiving 3 categories of claims, and the categories that he provided were simply inaccurate. The first category, he told Mr. Bryant that he was waiving the right to challenge any decisions made on motions that were filed after a hearing. That is arguably accurate. However, it's so narrow, it doesn't even apply in Mr. Bryant's case.
That's accurate.
This-
So that's true. Now, what is inaccurate that he was told?
The second category of claims that the court said he was waiving was the ability to challenge the factual sufficiency of the plea proceedings. That is not true. There are plenty of factual sufficiency issues with plea proceedings that can be challenged, even after a valid waiver of appeal. The court also said that Mr. Bryant was agreeing to waive any challenges to the length of his sentence, and that is not accurate because after a valid waiver of appeal, you still retain the right to challenge the legality of your sentence,
Okay,
including
but that's
its
not,
length.
that's essentially saying if you waive the right of appeal, you can't come here and say, argue what you're arguing, which is, in the interest of justice, reduce the sentence, correct?
It's
And on
saying
the
that, but it's
record-
also saying that, sorry.
On the record, did the court talk to him about the written waiver?
Your Honor, if I may just continue with the court's explanation briefly, the court also told Mr. Bryant that he was retaining the right to assert any constitutional rights, which is obviously overbroad. There are plenty of constitutional claims that are waived by a valid waiver of
Okay,
appeal.
but did he also speak with him about the written waiver, which would have clarified obviously, what the court said may have been smaller or bigger, but then was there a discussion on the record about the written waiver?
The court confirmed that Mr. Bryant had signed the written waiver.
And read it and spoke with his attorney about it, correct?
Yes, Your Honor. However, the written waiver is supposed to supplement or clarify a court's explanation. It can't correct an erroneous impression that the court leaves. The case law is clear that a written waiver can't be a complete substitute for an on-the-record conversation, and I would argue by that same logic, it can't correct an erroneous mischaracterization, affirmative mischaracterization by the court. That puts Mr. Bryant, a first-time offender, never been through this process before, in the position of having to decide, was what the judge just told me correct, or was what's in the written waiver correct? Should I not listen to what the court is telling me when the court is saying that I retain all of my constitutional rights and follow the written waiver, or should I do the other one? Because there's these huge this big divide between what the court actually told Mr. Bryant and what was in that form written waiver, this court cannot be certain that he understood the nature of his appellate rights, the consequence of its waiver, including what rights he was giving up and what rights were retained. Going back to the excessive sentence claim, Your Honor, Mr. Bryant also expressed deep remorse at sentencing when he was given a chance to speak by the court. He told the court, I want to apologize. I feel remorse. Now that I have this sentence, I'm going to rehabilitate myself to do better for my actions, and I take full responsibility for what I did. Thank you, Your Honor.
Thank you.
Good afternoon. May it please the court. Elliot Robert Hamilton for the Office of the District Attorney. The waiver was fine. 20 years for shooting a woman in the back of the head and killing her is not excessive. We ask that you affirm.
What about the fact that it was his first offense, counsel?
He shot a woman in the back of her head that he did not know whatsoever, and he expressed no remorse for 3 years, and was on the lam for a year, and then only decided to express remorse after the court said you have to listen to probation.
What was he supposed to do while he was on the lam? I mean, in terms of remorse, he's not going to have an occasion to express remorse when he's homeless and out on the lam.
He made two statements to the one to detectives and one to the prosecution, trying to justify his crime. He only expressed remorse when he was told by the court that he could change the sentence if he was not in cooperation with probation, and he faced 25 to life for, again, shooting a woman in the back of the head that he did not know. We ask that you affirm. Thank you.
Thank you.
Just very briefly, Mr. Bryant did make statements when he was first arrested. Obviously, this was his first arrest. He was facing extremely serious charges. I think that it's very understandable that somebody in that position would be very scared, very frightened, and despite that, he did tell the prosecutor that he admitted to causing the death of Miss Button by
He shot her, right? He shot her in the back of the head.
Yes, Your
And
Honor.
they were in line at a bodega, I believe, and he left and came back with a firearm, waited for her to come out, and shot her.
So, Your Honor, a lot of the facts that you just said are actually allegations that were made by the prosecution in their response that don't have any record support.
There's no record support that he left and came back?
There's record support for him leaving and coming back from his own statement.
There's video of that, right?
There's video from inside the bodega, yes. There is not record support for the idea that he laid in wait outside. There's not record support for the repeated assertion that the prosecution makes that he left in order to get a gun. And when I reached out to the prosecutor to ask where in the record that could be found, they did not provide me with any citations.
Well, perhaps the reason there's no record is because he took a plea, a negotiated plea, and therefore no trial record or record on suppression hearings was generated that would, provide a more fulsome factual picture.
Yes, Your Honor, and the fact that Mr. Bryant took a plea doesn't relieve the prosecution of their burden of arguing things that are based in the record. So in light of all those facts, the fact that Mr. Bryant had no prior criminal history whatsoever, this was not an escalation of violence, this was an aberration in a life where he otherwise had no police contact, and the fact that he did express such sincere remorse at sentencing where he knew that he was getting 20 years. There was nothing that was going to change at that point, yet he still chose to apologize in open court. I would ask Your Honors to reduce his sentence.
Thank you. Thank you both. And last for argument today is Iberdrola versus Oak Tree.
Good afternoon. May it please the court. Robert Mockler for Appellant, Iberdrola Energy Projects. Would ask permission from my colleague, Mr. Watson, from the state of California to appear.
Okay. Well, thank you. Welcome from the state of California to our beautiful courthouse. You may begin.
Thank you, Your Honor. Good afternoon. My name is Thomas Watson on behalf of Iberdrola Energy Projects, also known as IEP. The motion court's order here, which was issued without oral argument that dismissed our complaint, should be reversed. There's a lot of spilled ink in the pleadings over the non-recourse provision in the contract, but whatever it may mean here, the court's opinion can be much simpler and much more direct. The acts that we allege are intentional torts. We allege, and it's actually in some ways more than an allegation because the acts, many of them are confirmed in a judgment based on an arbitration award against the underlying entity, Footprint, that Oak Tree individuals lied to us. They lied in order to force the call of a $141 million letter of credit, and they lied to induce us to do extra contractual work.
So they have to do something affirmative, right? Because I read your brief, and it seemed to say that one part of your brief says that their status as corporate defendants is sufficient to expose them to liability, which is not the law.
I'm sorry.
I'm sorry, status. You argue at certain parts of your brief that the status of these individuals exposes them to liability, and I don't agree with that. So I want to give you a chance to convince me I'm wrong.
Well, certainly. I think the first point with respect to the cause of action for intentional tortious interference is that under very clear New York law, including the Kalish case by the Court of Appeals and the Bank of America v. Beresford case, intentional acts cannot be exculpated, no matter how clear and broad an exculpation clause is. We don't have that here. So we don't need to look at the details of that non-recourse clause with respect to intentional interference. It can't be that intentional interference here does not move forward based on a non-recourse clause under Kalish and Bank of New York. And I point out, actually, Justice Moulton, that the EPAC Technologies case reversed a motion to dismiss that was granted by the same court here about the exact same time, dismissing an intentional tortious interference claim, where, for the same reasons, that there was lying and fraudulent and improper conduct alleged. For those same reasons, under Kalish and Bank of New York v. Beresford, the exculpation clause or no recourse clause here cannot stop those claims from moving forward. And so we would ask that those claims be allowed to move forward. In addition, we should have the opportunity to replead at minimum. Under the CIFG case, the court should have given us that opportunity. There's no basis here to show that we didn't
Am I
have
mistaken? Did you take that opportunity? You did append an amended complaint, did you not?
We did.
So the court was able to evaluate that, presumably.
There's nothing in the
say
record,
that, but
and we didn't have oral argument. In addition, this was more than 2 years ago that our operative complaint was filed. In the interim, we have learned very much. There was discovery of Oak Tree in connection with a bankruptcy case. We have learned details and specifics that could enhance a complaint as to their active fraud, as to why they were acting.
Wait a second. You're saying that you can plead fraud-based claims
Yes, absolutely.
under this non-recourse provision?
Yes,
Based on what detrimental reliance?
absolutely. So under the Megaris case,
No,
okay, sure.
I don't want you, I want you to factually tell me what is your detriment, what facts did you allege to show detrimental reliance?
So we alleged, for example, that we expended extra costs based on the lies that were told to us that weren't
Didn't you have to
required
do,
under the
wasn't that
contract.
basically, we performed under the contract? Other than performing under the contract, how did you detrimentally rely?
Sure. We were lied to and told that, among other things, the deadline for completing the contract had not been moved, and that we needed to, as a result, if we wanted to get to a resolution with them on various issues, do extra performance. It's tens of millions of dollars we did because we thought we could avoid arbitration. But in fact, Oak Tree had already decided there was no way they were settling with us, no way they were resolving the issues with us, because they had already decided to terminate. So different from the cases cited, these weren't future promises. These were actual lies about present status of permits, present status of what
But
their
it didn't,
decision
it
was to
didn't
move forward.
convince you, that detrimental reliance didn't convince you to enter into the contract, right? You were obligated under the contract to
We were
do
obligated.
that.
Sure.
And if you wanted that extra money, you were obligated under the contract. So yes, that is exactly what it's saying, that it is not detrimental reliance in that claim, a fraud-based, because you didn't detrimentally rely to enter into a contract. You entered into the contract knowing what the terms were, and you performed under the contract knowing what the terms are. So I still, okay, assuming that I don't accept that that's detrimental reliance, what else have you pled?
Sure, sure. First of all, I do think that
Okay,
the performance was
assume that I
not
don't.
required by the contract. That's at least a factual dispute at a pleading stage.
Okay, let's
We al-
assume, let's move, I'm just saying, let's move from that. What else do you have?
We also spent significant time and money engaging in negotiations that were absolutely without any basis because it had already been determined, and this is new documents since pleading, that they had already decided they were terminating us, they were going to force us to work until the very end, and that was all a sham. And so we detrimentally relied on that. As part of that, we forbore taking remedies that we could have exercised, and we incurred great expense in those negotiations. And that's detrimental reliance based on lies. And it's very, I think, different from the case law that talks about, it's not as if they said, we promised to pay you, and that was a promise about a future event. These were
So
actual
what
lies.
are you seeking, what are you seeking to hold the parents, despite the non-recourse that says you won't hold the parents, what are you seeking to hold them liable for?
We're seeking to hold them liable for intentional interference with our contract. They were a third party to it. We meet the elements.
No, but you're seeking, but you're saying that the underlying party breached, right? That's what you're seeking. You're seeking the breach damages that you don't think you're going to get from the underlying party, correct?
So it's now established we're not getting them from the underlying party.
I understand, but that's what you're seeking. It's not like you're seeking something else. You're seeking the damages the breach damages that you got from the underlying party, right?
They're actually different, Your Honor, because if I may have just, under the Albemarle Theater case and the Hornstein case,
How much are you, what other than those damages are you seeking from?
sure, for the intentional interference, there are additional damages that are different and above the contract damages.
Which are what?
The extra costs that we incurred, and
You mean trying to negotiate a deal?
For hiring additional people to try to complete the contract? Is that what
yes, there were additional people hired, additional contractors hired that weren't required under the contract, but it's approximately $300 million. They intentionally interfered, and nothing in their briefs refutes the fact that no recourse clause does not cover, under binding New York law, intentional interference claims. And the fact that there were contract claims based on contractual obligations does not allow them not to be held liable here for their separate independent duties under New York law, not to lie to us, not to defraud us, not to interfere with our contract.
Okay, let's hear from your adversary, and you'll have a few minutes to respond. Thank you.
May it please the court, Ashley Parrish for Oak Tree and the other respondents. Your Honors, they're really caught between two problems. One is the very broad non-recourse provision that a sophisticated party they agreed to. And
Is there a carve-out for tort claims?
No, Your Honor, there isn't. But what I'd say what's reinforced by that are your questions, which is that we also know that regardless of a non-recourse provision, we don't allow contract claims to be redressed up in the version of fraud. So those two things work together.
Was Iberdrola required under the contract to do whatever it's claiming now that it did and that it wouldn't have done if it knew it wasn't going to get paid?
Yes, Your Honor, and what I would say is two things about that is that one is if you look carefully at the arguments about reliance, every one of their defenses falls back on a contract dispute. So that we say, they say, we would have terminated earlier, and we say, well, you couldn't have terminated under the contract because the contract didn't give you the right if there was a bona fide dispute. And the arbitrators found that there was one, and they come back in their brief and they argue, well, that wasn't legitimate because Footprint violated its obligations. And so every one of their fraud claims falls back ultimately on a contract dispute. But Your Honor, just to be more specific, if you take a look at their amended complaint and then you match that up with their statement of claim, they say it was halted required payments. Well, that's on R206, 225 of their statement of the claim, the exact same allegations.
What about the intentional claims, the intentional interference claims?
Your Honor, I'm sorry. What I was just saying to you very quickly was the allegations they make to support that. So in their intentional tortious interference, they talk about that they halted required payments. That duplicates an allegation that they had in the arbitration. They said that they denied change orders. That duplicates, and I can give you a page for that. They say that we improperly terminated. It duplicates the same claim that was arbitrated for many years. Your Honor, what I would say is that they make this big argument that there is this hard and fast rule that non-recourse provisions can never go beyond contract claims. That just isn't true. If you take a look at the case they rely on, it has no analysis. It just applied the facts to the particular circumstances of that case. What we say is you always have to look at two things. One is the terms of the provision and how broad they are, and two, the nature of the claims and whether they're actually fall within the provision or whether they are actually true tortious interference claims. That's really important in the context of tortious interference because, as Justice Schechter recognized, if you read that too broadly, then it renders the non-recourse provision meaningless because tortious interference could always be pleaded.
You can convert a breach of contract claim pretty readily into a tort claim that would, if you say you could never, a non-recourse could never be covered by a tort claim could never be covered under a non-recourse. You could repackage it and then get out of the, right.
Which is exactly what they're doing here. And Your Honor, I mean, the problem, of course, with that is that the whole point of these contractual agreements, and this is why the non-recourse provision is so specific, it says it only applies to Footprint. And the reason for that is you want a closed system. Everyone understands there's risk. And one of the things that they're not taking on the added risk is that you can then go ahead and turn around and sue the parents.
So let me ask you, at the time the contract was executed, they understood that that you were creating a single-purpose entity for this project, right? It wasn't a surprise.
It was not, Your Honor, no.
And then, right, so they knew that you were, that was pretty strong evidence that you were trying to limit your liability. And then you negotiated for the non-recourse in that agreement.
Your Honor is absolutely correct.
And there is no guarantee provision also, which there could have been.
You're absolutely right, Your Honor. The only thing I would add to that, but I don't need to, is that these issues came up in the arbitration, and they made the same arguments there, and they were rejected by the arbiters. Your Honors, I see I'm almost out of time. All I would say is that Justice Schechter got this right. If you look at their cases, they don't say what they say they say. If you look at the just plain basic law, you can't repackage fraud claims or contract claims as fraud claims. And this type of broad non-recourse provision by this type of sophisticated party deserves to be enforced. But if you have any more questions, otherwise, I thank you for your time.
Okay.
Thank you very much.
If I may briefly, the award does not say what Mr. Opposing counsel said it says. In fact, they found repeatedly that there had been lies, repeatedly that there had been misrepresentation.
Well, I think they found that both parties were pretty. I wouldn't stand there and say the arbitrators found my client to be an angel with wings. I think
no question.
Both sides were pretty aggressive, took pretty aggressive stands. So I think there was the arbitrators found there was plenty of blame to go around, right?
They did find that, but ultimately they decided that the letter of credit was not correctly called $141 million and awarded us $237 million. So,
but this isn't a collateral estoppel res judicata situation, right? We're not concerned with that. So what we're really concerned with, are there any species of causes of action that can survive this non-recourse?
That's correct. And
so one of the main points your friend was pressing was that you can't repackage a fraud claim, what was otherwise some sort of contractual claim, to a fraud claim. And how do you respond to that?
Well, that's just not true. This is wrongful acts by a third party. In the Albemarle Theater case and the Hornstein v. Podvitz case, make it really clear that this repackaging is something they've made up. It's not that we're suing the defendant or the underlying counterparty Footprint for fraud. We're suing a third party for separate fraudulent acts, but moreover for intentional interference. Intentional interference with contract wouldn't exist if there were repackaging, right? It's an entire species of tort, long recognized, that is based on something going wrong with an underlying contract, a breach of an underlying contract. You can still sue the parties that caused that breach wrongfully. And hopefully that answers your question. Just a couple other very brief points. With respect to the language of the recourse provision, as Your Honor discussed in the prior case, there could have been much clearer language here if this was intended to exonerate torts. It doesn't say that in any plain English meaning. There's also a no third-party beneficiary clause here. That at minimum creates a need for parallel evidence and discussion about what this ambiguity at worst means in the contract. At best, there's no way a non-recourse clause. You can't uphold it, I would urge, based on intentional fraudulent conduct. You can't pre-release torts. And then just finally, just for Justice Moulton, absolutely, we do agree we can't sue them because of their status for negligent acts or otherwise, or in reliance on the contractual obligations of Footprint. That language does mean something. It has meaning. If we were bringing contractual claims, alter ego claims, yes, it would apply.
You're referring to as such?
I'm referring to as such, yes. But again, I think the key thing here is at the pleading stage, we should either be given the right to replead or intentional interference and fraud should be allowed to proceed because the no recourse provision does not apply here. Thank you.
Okay, thank you.